first of all, we're going to talk about the 7 mandatory components of a good foundational estate plan. And this is your replacement for your will. Urgent, urgent. Tune in, stay all the way to the end of this episode, because all of these 7 are so important. And again, the wills are outdated now, so you need to know these things.
Welcome to the Jennifer J. Hammond Podcast. Jennifer is a licensed realtor, educator, speaker, and best-selling author. Jennifer's goal is to help you find your yay in every day.
Hello. This is Jennifer J. Hammond. I'm here with a wonderful guest. This is a topic also that I know we avoid it because it kind of gets into touchy subjects. So yes, I'm super excited. We have Will Andersen. He's here. He is an attorney who does, I'm going to say wills because his name is Will, but he does wills and estates. And I know, wait, I'm getting the naughty. I know. So, but today, first of all, we're going to talk about the 7 mandatory components of a good foundational estate plan. And this is your replacement for your will. Urgent, urgent. Tune in, stay all the way to the end of this episode, because all of these 7 are so important. And again, the wills are outdated now, so you need to know these things. So, Will Andersen, welcome to the show.
Thank you so much, Jennifer. I appreciate you having me. This is just fantastic. And by the way, you completely made up and more for the will comment with the exactly right thing that you need to replace it. So,
well, people don't always understand. And so one thing I've learned is you have to talk in the language they understand first. And most people only think about a will. Or don't want to think about a will. They just don't want to think about anything to do with death. Death is a topic.
Well, it's common knowledge. Yeah. It's what you hear on the radio. It's what you hear on TV. Have you done your will? Do you have a will? And so, hey, I'm just joking with you. I do the exact same thing. If I have to talk about, have you made your arrangements? Yeah, fine. Will is okay.
Right. And it makes people feel uncomfortable to talk about this. So first of all, let's give it a little bit of background so that people know who you are and how again, it's just, for a lot of times people think about going to law school, but they don't think about going to law school. And then guess what? I want to choose probate or wills or, it's not necessarily the idea especially when you think about law school, you think about the trial attorney or a different kind, or corporate attorney, someone who's not doing this per se. So tell us about yourself, Will.
Sure. No, thank you. And so my name is Will Andersen, and I'm an estate planning attorney with the Andersen Firm. And we have offices in New York, Florida, and Tennessee, but we help clients in all 50 states and international. But you are so right, Jennifer. The estate planners are an odd bunch. Anybody who comes out of law school and says, you know what I want to deal with? I want to deal with death and taxes. I've got some questions. Okay. Now for me, it's a little bit different. I was raised in this. I say that my first job at the Andersen Firm was block player on the floor. So my parents started this firm when I was 3, but then I held every job from answering phones before my voice had dropped, so everyone thought I was a woman, to marketing, to HR, to attorney, partner, managing partner, president. So at the end of the day, this is the only thing I've ever really wanted to do. And so I'm a lucky guy. I like to say that I didn't choose estate planning chose me. So.
And it's perfect because it's a family tradition and it's one that you're really passionate about. I mean, not everybody wants to continue their family's legacy or whatever the family business is. It's not always interesting to the next generation. So, well, I am so excited because you are so passionate about teaching people and helping people so they don't make mistakes. And so let's talk about the 7 mandatory components of a good, and I'm going to emphasize good, foundational estate plan. So, and I think I'm going to probably start with what is the difference, because people ask it all the time. And as we started at the top of the hour, what's the difference between a will and an estate plan? Let's define these terms.
That's a great question. And a will is really part of an estate plan generally, but the anytime that we're using a good solid estate plan, it's going to be based around something. And now, what is that something? Is it a will? Is it a trust? And I'll say my corny joke one last time, and that's that I'm the only correct will in estate planning, Will Andersen. Look, I know it's bad. I don't get a lot of
Will Andersen, who recommends against just a will.
That's right. That's right. I wish I could say better things about him. But at the end of the day, a will is your ticket into court. And a lot of people don't realize that they think that I've said in my will what I want to have happen. I've listed my executor, and they're going to go and do the things that I've written in my will. But in reality, what that is a document that your executor is going to have to go and take to an attorney who's going to file it with the court. And then to boil it down to the most simple terms, the court is the one that's going to go and do the things that you said, and they're going to use the executor as their hands. Now, when we do this, we have now started a court proceeding. We have started a public court proceeding. A lot of people don't realize that this document, you can go down to the county courthouse and you can pull the will of anyone who's ever died, and you can see, who got what. You can see, in some cases, addresses. I always ask people, if you've ever dealt with a probate, then did you start getting a bunch of junk mail from people offering to help you settle the estate? Well, they say, well, yeah. How did you know? Well, there are people whose job it is to go to the court, pull all the wills, and start spamming you with junk mail so that they can help you settle the estate. So to make a long story short, it's not even the wills that I'm so angry about. It's the probate that I really don't like. I shouldn't say angry, but I just don't like them. And the reason I don't like them is because when we have a probate, it is going to be time consuming. Generally, you're looking at least 7-8 months on your best case scenario. That's assuming nothing goes wrong, everyone plays ball, we don't have any problems. But then you have certain situations where you're looking at years potentially. I mean, I think the longest one that we have right now is one that's been going for 5 years. I've heard stories of ones that have gone on for 20. And this, it's just something that's unnecessary. Now, when we have a long court proceeding, what does that come with? And think about me.
Children, attorneys.
Well,
I was going to say all the different people that are in that lineage.
No, you're right.
They're all going to come in and be part of that. And, ooh.
Yeah, no, you're right. And so, but the thing that I'm pointing at is the attorney's fees that come along with this are massive. You are looking at, in many cases, a percentage of the estate by statute. That's in many states of what an attorney can charge for a probate. And so the attorney is going to make a lot of money off of this, but you or your family, I suppose, they're going to be waiting a long time to get access to everything. They are going to have it in the public eye. It's just the only person that I see a probate being good for is me, the lawyer. So that's not how we do business. And I always prefer to use a revocable living trust-based plan for every client. Yes, every plan is customized for a person, but whether a person has $100,000 or $100 million, we want to make sure that they have a good foundation set, so that whether we need to build a tax house or an asset protection house on top of it, we got to build the foundation first. So that is where the revocable living trust comes in. And so for the revocable living trust, it is what some people call a will replacement. Now, I'm not a huge fan of that term. It's true, it is a will replacement, but the reason I don't like it is that it can imply that a will can only do, or a trust can only do what a will can do, when in reality, it can do more because it's valid. Go ahead, Jennifer, what's that?
I was going to say, because it's so much more. I mean, I just wanted to stop you just there for a second to say that's one of those things that, again, is the confusion is people think that a will is all they need and that there isn't really any need for something kind of bigger or more. Because again, I hate to say, this is one of those learning curves that you don't really learn until after someone dies and you're stuck in the middle of it. Usually. I say usually, because I've seen it so much with my clients, and it's just, and even my own family members, and it's really frustrating. So I just wanted to stop you, pause you for a minute and say, it's just a huge I don't want to say a lie, because it's just that people don't understand it. It's a misunderstanding that people have about the transition when people are dying, the transitions that people have to go through. And again, what do you need to know? It's so important. So thank you for that.
No, you're so right. And I mean, look, there's not a lot of gunshots and explosions in estate planning. It's not a comfortable topic. So of course we revert to the easy thing to say that everyone's going to know. But you're right. That's why these things are little known. But when it comes to using that revocable living trust, first thing, anything that we put in it, which if we do everything right, should be everything, it is going to avoid probate. And so if we have everything funded correctly, we essentially give the court a piece of paper saying thanks, but no thanks. We are handling this with a trust. If somebody wants to come and sue Jennifer's estate and say she owed me money, then you can send them to the trustee. Other than that, have a nice day. And because we are able to cut the cord out of the process, now we can settle a trust in a month and a half, 2 months. We're really more at the mercy of the beneficiaries and how quickly they can move than we are we waiting for the court to okay us getting rid of this timeshare we got suckered into buying. And so my philosophy on this is, let's do it quickly. Let's do it privately, which that trust is. No one can ever see a copy of that trust unless you named them in it. And let's do it in the most cost-effective way possible. And because it takes us a month and a half, 2 months, as opposed to potentially years and court proceedings and the like, the cost of settling a trust is a fraction of the price of settling a will. And this is one of the biggest misconceptions in estate planning, is that getting a trust is expensive. If I can go over here and get a will done for $800, but you want to charge me, $4,500 for a full foundational estate plan with a revocable living trust, or sometimes more. Well, yes, it's more work on the front end. But because of that, you are saving your beneficiaries untold amounts of money, because they're going to avoid this probate, this court proceeding, this whole thing. So it's a much better mousetrap.
Absolutely. So now that we've talked about it, so definitely this is an important part of not having a will, but having a good foundational estate plan, including, of course, this, you said revocable trust, right? Let me get all the words right. But you talked about there's 7 mandatory components. Let's talk about what are the mandatory components of that.
Yes. Well, the revocable living trust is number 1. That's
Okay.
your centerpiece of the estate plan.
Okay.
Now, the second component is what's called a pour over will. This is the only will you should have, and it is effectively a safety net. It's saying that, hopefully we got all of our funding done correctly, meaning we put all of our stuff, all of our accounts, all of our property, we put it into our trust, but maybe we opened that account 1 year for the holidays and it's still got my personal name on it and I forgot to close it. Well, yes, that one account may go through probate, but at the end of the probate, because you have this pour over will that just says, I leave everything to my trust, that's where it's going to go. And so this thing is a document that just makes sure everything will end up in the trust no matter what. It's a document I'd rather have and not need than need and not have.
That's such a great phrase, to have and not need. It's always good to have something you may not need as a protection, rather than have to.
Well, that's way better than needing it and not having it.
Well, and I think about that with car insurance. You get into a car accident and it is very expensive if you don't have car insurance. And yet, again, and it's funny because we have other things like title insurance that we talk about a lot in real estate. And there's all sorts of different, choices that you have. And I'm like, I'm going to tell you, I know you're thinking it's expensive at this moment because you're sitting at the settlement table, but I'm telling you, if you need it, it's the cheapest insurance you've ever bought. I can give you lots of case studies on that, on why that's true. Just like car insurance, car insurance, yeah, it seems expensive or it seems like an unnecessary thing until you get into a place when you need it in your life. So
that's right. I agree 100%, but I do subscribe to the Chris Rock school of thought, which is in case it's for in case. Well, what if nothing happens? I feel like I should get my money back. That's a different story.
Yeah, Yeah. What I was going to say. And so to take care of people, I hate to say, guess what? You're going to die. So that we know for sure. And so let's figure out how we can make it the best scenario for all of those that you leave behind.
Right.
That's the part of having a good foundational estate plan, is making sure that you have what you need. So you said, first of all, of course, the revocable trust, then the will.
The pour over will.
Pour over. And so explain, what does pour over mean? Why is it?
And so, like I mentioned before, it is a document that says if you didn't fund something, if you did not put it in the name of your trust, then yes, we're going to have a probate, but at the end of the probate, it'll be poured over into the trust where we wanted it.
Okay. I missed that.
I'm sorry, one, I didn't say it. That's the problem. But but at the end of the day, this document just says, I leave everything to my trust. And that way we know it's going to end up where we wanted it in the first place, by being poured over into the trust.
Got it. I missed that because I was like, I don't understand what the word pour over means.
Great question.
So, yeah, important that we know what that is. Okay, so then what's number 3?
Number 3 is your healthcare power of attorney, healthcare surrogate, healthcare proxy.
Yep.
It has many names, but they all do the same thing. And that is, who makes your medical decisions in the event that you can't make them for yourself? You get a bump on the head, the doctor needs to operate right now, but you are not conscious to give consent. Who does he look to give consent on your behalf? Who gets to make your medical decisions for you when you can't do it? And so it's a simple but very important document. And I think that one thing people really need to think about, a lot of times people just scratch down, okay, these are the people that I like, or these are my kids and I don't want to leave one out and the like. This is a very important decision. Who is going to make those decisions? And it's important to pick people that have like views to your views. And I think that Jehovah's Witnesses are a great example of this. For them, they don't want to put someone on this document that is going to give them a blood transfusion, because that's against their own beliefs. But likewise, a person who would want that transfusion may not want to list a Jehovah's Witness as their healthcare power of attorney. Because I've had people say, well, I don't want my child to feel left out. Say, stop. That's not what this is for. When push comes to shove, when it is time for a decision to be made, who's the person that's going to make the same decision you would? So it's a simple but very important document.
Yeah, I was going to say it's really important that you have somebody who, and that is, I think you've also said it always has to be updated, right?
Yes, every 2 years is what I generally like to do with my clients. And the reason is, with this and with financial powers of attorney, a lot of people don't realize that banks, hospitals don't necessarily have to accept these documents.
The first time you told me that still gives me goosebumps, to think that the hospital or the bank doesn't have to accept that power of attorney for financial or for healthcare, because healthcare, I mean, by the time you could argue with somebody, it could be too late for whatever you're trying to do if it's an emergency situation. So that's a little bit scary.
And they call it a staleness issue. They say this document is stale. It has been 10 years since you did it. And so I like to make sure that even if with this we do a 2-year follow-up with our clients and say, look, anything changed? Here's what your plan says now. Is that still what you want? If you say yes, that everything is still the same, I'm going to shoot you some new powers of attorney just to make sure that it keeps being that way. So it's important. Now, number 4 on this list is what's called a living will. And I hate that they called this thing a will, because a lot of people, I've had multiple people say, I have a will, and then they send me their living will. That is not what this is at all. What the living will is, I prefer to think of as the Terry Schiavo document. I don't know if you remember that case. It's been 15 years now. South Park did an episode on her. I mean, it was national news at the time. But effectively, Terry Schiavo was a woman who was separated from her husband at the time when she was in a permanent, terminal, irreversible vegetative state. And at least that's the medical term. She was in a coma that she's not coming back from. And the husband, who, again, they were separated, said, oh no, we talked about this. And she said, if this ever happens, to pull the plug, let her go into her good night. The parents said, oh no, not our baby, not our baby. You can't do this. And so all of a sudden, there is this giant court battle. And I believe it went to the Supreme Court. There's a big Wikipedia page on this case, if anybody's curious. But it was all over national news. And so I always say, if Terry Schiavo had had a living will, we would have never known her name. And so what this document does, very simply, says, if you are ever in a terminal, permanent, irreversible vegetative state, do you want to be kept alive by mechanical means and tube feeding? That's machines and tubes. And look, it's not an extremely fun thing to think about, but I want you to focus on those three words: a terminal, permanent, irreversible vegetative state. You're not coming back in this scenario. So at the end of the day, it's important that we make that decision now while we're still okay, so that we don't end up getting plugged up to machines because people are working off of emotions rather than what you would have wanted to have happen.
Yeah, exactly. Very, very important is to have that in writing and clear. So again, that it's not an emotional confusion. That's what I want to call it, an emotional confusion when it happens to someone you love. Oh my gosh. Okay. So we're talking about the 7. These are the 7 mandatory components that you really need to have in your estate plan. So, okay. So next one is number 5, right?
Yes. Well, and so we've done revocable living trust. We've done the pour over will. We've done the healthcare power of attorney. We have talked about the living will. And so that's 4. Now, 5 is going to be that financial power of attorney. Now, with this one, in a good estate plan, it's used a little bit differently than what you may have seen in the past. And I say that in that if you are using a good trust-based plan, you will have listed who handles your finances during your disability in the trust. But a trust can only manage trust assets. I think of it like the rules to a co-op board. Right. For you New Yorkers, you know exactly what I'm talking about. But think about, if any of you guys have a homeowners association too. At the end of the day, if the rules that they set, they only cover homes that are within that area. They don't control the Walgreens next door. Right. And so your disability trustee can handle everything that's in your trust. But what about the stuff that isn't in your trust? That account we mentioned earlier that we opened for the holidays, or maybe it's an IRA, a 401k, a 403b, a retirement plan. Well, any of that stuff cannot legally be owned by a trust. So I would hate to get in a situation where this person can handle everything except for your retirement plans. So we need to make sure that we have on the financial power of attorney the same people listed as we have as our disability trustee. And that way we have the same people handling what's in the trust and what's out of the trust. And if it's not in the trust and it's not out of the trust, I don't know where it is. That
yeah, exactly. It's either in or it's out. Okay. And what's number 6?
So number 6 is a quitclaim bill of sale or an assignment of personal property. And what this is again a very simple document. A lot of times people say, oh my gosh, I feel like I'm selling everything I own with all the signing I'm doing. Well, you kind of are, but this document sells it from you to your trust, so from yourself to yourself. But what it does is it makes sure that I don't have a probate on your stuff. I don't want to have a probate on your couch and your TV, your socks, your spoon collection. That would be silly. We do all of this work to make sure that everything gets into the trust. Well, how do I show the ownership of your couch? It's tough. But if we do an assignment of personal property, it's just a document that says everything I own, all of my stuff, and we list out as many categories as we can think of, and then say, and everything else too. I hereby give to my trust, and that way I can say it's all in there. We don't need to have a probate. Forget the couch, forget the TV. It's all in the trust. So simple but important.
Very, very important. I know that from real estate. And so what is number 7?
Number 7, and this is where most attorneys fall down on the job, is a good funding plan. And you've heard when I talk about funding, that just means putting it in the trust.
Right.
We do all this good work. We create these great documents that do all these wonderful things for your beneficiaries. But what about for getting the things in there? I can create these documents, but it's not your job to know how to do all of this stuff. It's the attorney's job. It's what they do day in, day out. Well, you heard me mention it last time. A lot of times they'll give you a little one pager that's a generic one pager that says you may want to put your checking accounts in the trust. You may want to put your personal property or your real property and the like in the trust. They're doing just enough to avoid a malpractice action. So they say, see, we told you, look, you got the sheet right there. But
Exactly.
if you do it correctly, proper estate planning is done asset by asset. You have to take a list anyway of every single asset that a person owns, and then we make a plan for each one. So if a funding plan is done properly, then we're going to have a list that says your checking accounts as of this date are at Wells Fargo, and they are currently in this name. We want to retitle them into this name, and here are the documents that the attorney is providing you to make that change. So that all you have to do is go into Wells Fargo and hand them your little stack of papers and say, I did some estate planning. Can you please change the name on my account? And we go through a checklist of every single asset you own, make sure that we have effected the plan for each one, whether that's a deed, a beneficiary designation, it's the paperwork that the banks need. We make a plan for every single asset. And so that's a proper funding plan. But watch out, if you've got a little one pager that's saying, here is where all of the, or here's what you may want to put into your trust, ask a couple more questions.
Well, and I was going to say, I have so many more questions for you, but we are completely out of time. And I also, for any of everyone who's listening, we have a whole series that we're going to do. And the next one we're recording is Where You Live Matters and the Importance of Your Domicile. And we're going to talk so much. We have just so many great ones coming up, but I want to make sure that people know how to get a hold of you. So Will, how can they get in touch with you?
Sure. So you can go to our website, www.theandersenfirm.com, and that's Andersen with an E, Andersen. And you can also give us a call at 866-230-2206. And we'll schedule a call and we'll